5 minutes past 10, time for you to be able to get some free legal advice from our talkback lawyer, David Whiting. 1300 222 774 is the number, 1300 222 774 if you'd like some free legal advice. And David, good morning to you.
Good morning, John.
The Justice portfolio, or the Attorney General's position in the new government, will be interesting. They're having a shuffle, perhaps today or tomorrow.
Okay.
They're negotiating this right now. So out of 10, what do you give the Attorney General, Martin Pakula, and do you think it's a good idea that they keep him there? Or
I thought he'd done a pretty good job.
Also Minister for Racing.
Oh, that's important.
Yes.
But that's you go back to Arthur Ryler's day. You go back to the 60s when Arthur Ryler was the Chief Secretary. He had racing. He was a very important man in racing. I think he was the attorney as well at one point.
Arthur Ryler, wasn't he the man? He was the minister that used to censor books in the Balti government.
I had a particularly honourable job, John, but at least you get to read them first.
And I think, was it Rossiter? I think it might have been Sir Henry Rossiter?
Sir John Rossiter. Yes.
Who was the father of...
The father-in-law
Mrs.
of
Peacock.
Mrs. Peacock. Yep.
He was the father of Mrs. Peacock, who married Andrew Peacock, who was... Anyway, let's not go through the genealogy of it all,
Yep.
but he used to, I think, censor books in Victoria in the 1950s on the basis of what he thought his daughter should be able to read.
Okay. At least we know it's an objective standard, John. Yep.
Oh, those were the days. So we'll see what happens. I think Martin Pakula has actually been a very good Attorney General, and I have no idea whether he's any good as a Minister of Racing, because I wouldn't have a clue. But yeah, it's all up for grabs as we speak. We also have federally, we spoke to Cathy McGowan, the independent member for Indi, and earlier this morning heard from her latest efforts to try and get a national anti-corruption body called the NIC, the NIC. They want to call it the NIC, the Labor Party say, so that they can say, you're nicked. Now, everyone's kind of got used to the fact that it's inevitable that we're going to get one. Now the argument is what sort of shape it'll have.
And when it will appear. I mean, there was a long ad in yesterday's papers signed by 35 former judges saying this is something that we think we should have, including Gerard Brennan, former Chief Justice of the High Court. So a goodly number of well-reputationed judges coming along and saying we need something like this.
If I didn't want an anti-corruption body, and I was a politician, for instance, on the Conservative side of politics who are a bit hesitant and reluctant, everyone else is committed to it, I guess what I'd do is I'd say, yeah, we do need an anti-corruption body, and what I'm going to do is refer it to the Law Reform Commission so they can advise us on exactly what model it should be, and that pretty much makes it go away for a couple of years, doesn't it?
Yes, it does, John. If you don't give them a time frame.
Don't know why they don't do that.
Well, it's not Christmas yet. That could be a decision we could make in the next couple of weeks, is it not?
All right.
I think we ought to have one. I think, you look at what happens. They're in every state. They would appear to be, on the basis of 99% of the reports that you receive, well worthwhile. Yep. Adding value to the system that we have. I think we should have one.
It's a no-brainer. What else is around?
Well, Canberra's proving to be interesting, John. There's a move by a Labor backbencher in Canberra to introduce a private members' bill into the Legislative Assembly in Canberra to allow cannabis usage. So you can have up to 50 grams or 4 plants and you will not commit an offence. Now, there's only 25 members in the Parliament in Canberra. So it would only require one vote from the other side of politics to get up, because all of his party is on board. Mm-hmm. So that would prove to be interesting. I only pass one message of warning, and that is that because of the way that territories are structured, federal parliament has a veto right, which they exercised in right-to-die legislation in the Northern Territory.
So it's used rarely.
No, used very rarely, but it would be interesting to see what the response would be in Parliament Hill, Capitol Hill in Canberra, to what happens a little bit further down the road.
Watch this space.
Now, the one that caught my eye was that if you've ever been to Barcelona, there is this most extraordinary church that is in the throes of construction, and it's their major tourist attraction in Barcelona. And they've been building it now for 136 years. Construction started in 1882.
136
years, and it's not finished. All right, now
It's not like some of those villages in Greece where, you know how you only pay property tax when the building's finished, so you make sure you never finish, so you never pay tax.
Yeah, and I've heard those stories. Yes, no, that's not that. It's been ongoing work to finish substantially in accordance with the original designs for 136 years. However, it would appear that for most of that they haven't had a building permit. So last week, the city government in Barcelona has fined whoever owns the basilica, and I don't know who it is, but it's not the Catholic Church, have agreed to pay 36 million euros to the city in what is more or less a fine for building without the necessary permits. So, you know, clearly in Spain you can take it so far and then it's enough.
Well, that's a good one. Do they actually have to pay the money?
Yes.
Like, what happens if they don't?
Well, it seems to me that if you closed it down because it didn't have the necessary permits, then they'd need to restructure tourism in Barcelona. It's the thing that everybody goes to.
Yeah, well, I mean, someone owns it, I presume. It's got some legal entity.
Well, it'll be some church organisation
or a
that will
trust,
own it.
or I mean, the equivalent for us of a trust.
Yes, because somebody's paying for the building.
Yeah. Oh, wonderful. Love it. Great story. Thank you indeed. Stephen in Cheltenham is first up with a question for you, seeking some free legal advice from our talkback lawyer, David Whiting. And Stephen, good morning to you.
Good morning, John and David. Thorny one, David, getting into territory that I know you don't like exploring. I am extremely angry and upset with a solicitor acting for me.
Yes.
In 2013, I engaged this firm to commence an action against the Catholic Church for reasons which you can well imagine.
Well, I can speculate about. Yep.
Fair enough. David, it's been going on since that time, and this is not, Fred down the road.
Don't say who it
Stephen,
is.
why? Can I say?
Go there.
Oh, okay, so have they issued?
No, they have not. In 2015, I wrote a letter of complaint to them saying that nothing has happened since 2013.
Yep.
They responded saying that they were entering into an alternative dispute resolution process with the defendants.
Stephen, you're the client.
Indeed.
I mean, they can't take a major step, or they really shouldn't do anything other than what's in consultation with you or that you've directed as part of the instructions that you give them. Why 5 years on are you still with them?
David, I had a telephone discussion with the principal of the firm, which took a lot of pressure to get a couple of weeks ago.
Yes.
She said to me, let's leave it another 4 to 6 weeks and then we'll consider issuing. I was saying, well, look, no, I want to instruct you to issue proceedings.
Yes.
She said, look, it might take just...
Can I say, Stephen, are you on a no-win, no-fee basis?
I am.
Because, in a sense, that means that you've got to give away some of the control because it's an action that you're sharing with them rather than an action that they're conducting on your behalf.
Understood, David, but the extraordinarily long period that this is taking, coupled with the fact that when I engaged them initially, I put a rider on the agreement saying, well, look, I want to be involved in any settlement discussions, and it is my belief that the church as the defendant should meet all costs in the matter.
So as it stands, let's just approach this in the same way you would any other piece of litigation, David, because whether it's to do with priest abuse or whether it's to do with debt collecting, the principles are the same. What happens if you're not happy with the way your lawyer is looking after your case?
Stephen has a problem because one of the things that Stephen did was that he entered into an agreement with a law firm that was a no-win, no-fee.
Yeah.
Now, if you appoint someone in circumstances where the vast amount of the risk passes to the lawyer,
yeah,
the lawyer says, well, in these circumstances, I want to have more control and more say than I otherwise would.
But that you don't...
And you still have...
It might be more, but it's not complete
No, it's
control.
not complete.
They don't have complete control.
No, but they might have the ability to determine the terms of settlement, for example.
But they haven't even issued here.
No.
So if they haven't even issued, what does Stephen do? Does he
Well,
take a
Stephen's
complaint?
right is to come along and say, you failed totally in what my instructions were.
Yes.
I'm taking the file away.
Should he write a letter saying you've got one more week in which to issue proceedings, or I'm going to other lawyers and I'm going to ask for my papers to be transferred somewhere else?
Well, I would start with, I want a written explanation as to why you haven't issued and why it's taken us 5 years to get to this point of you not having issued. And depending upon the outcome, I will either take the matter up with the regulator, the Legal Services Commissioner, but in all likelihood I will be taking my file and I will be disputing your claim as to costs having regard to the delay. Does that help you, Stephen?
David, if I were to take my file from them,
Yep.
would I not be obliged to pay them at that stage for their outgoing?
Well, it might be possible that those costs would be that they would defer their costs until there was further. They would defer their costs until completion of the matter. But I would have said with 5 years and substantial delay, you've actually got an argument about what the costs ought to be.
And there might be, are there medical reports and so on as well, Stephen, that they've dispersed on your behalf?
Yes, John, I've had one visit to a psychiatrist.
A consulting psychiatrist. So what's typically happens here, David? Do you enter into an agreement, a written agreement, saying, OK, I agree so far you're owed X thousand dollars for the work you've done, and when this case is resolved by my new lawyers, we agree we'll pay you for that part of the work you did?
And what you might take it is one step further, and you might get an agreement where the new lawyer says, and we guarantee that from the proceeds of settlement we'll make the payment.
But it all has to be done in writing now, Stephen. It's beyond the point of talking. It has to be done in writing.
It has definitely been done in writing, John.
All right.
I only resort to the telephone when the buggers don't answer their mail.
Well, the alternative is for Stephen to choose who the new lawyers might be, and the new lawyers deal with the old lawyers. David, does that often work?
That works. But I'm interested in a sense, the size of Stephen's bill.
Yes.
They're interested in when they get paid. I'm interested in this stage at the size.
Yeah.
Why has it taken you 5 years to not move an inch?
Yeah.
Is Stephen's argument.
Yes. And Stephen, have you found new lawyers already?
I haven't, John. It's whilst I accept it as something I might have to do, it's not something I'm keen to do.
No, I'm sure you're not, but it sounds to me as if the relationship is completely broken down, and that's what you're going to have to do.
Well, my other question, John, is sometimes it's not the firm, it's the person at the firm who's got your file.
Yep.
So that might be a discussion that's worthwhile with the partner in charge.
That's why Stephen had the meeting with the principal, so that didn't resolve it. So, Stephen, you've got to take drastic action by the sound of it. Good luck.
Thank you very much indeed, gentlemen. Much appreciated.
Douglas in Black Rock, good morning.
Oh, good morning, David and John. My little situation's much less interesting than either your preamble or your previous caller, but it's a simple one, I hope. I'm a member of a small sort of quasi-environmental organisation. It's properly constituted, it has members, and we collect very small fees and pay for postage and so on. The secretary is concerned about if he has to write a nastygram, to put it politely, to a minister or someone on that.
I would have thought environmental groups wrote nastygrams all the time.
And therein lies the question, David. Is there any advantage in being an incorporated body on the basis that the secretary could then only be sued as the secretary?
No, the secretary could still be sued. What you're talking about is liability for what you write.
Yes.
And if what you write is defamatory, it doesn't automatically follow that because someone else has asked you to write it that it's not your defamation.
Right.
That the general proposition, I mean, I look at it a different way, Douglas. I'd say incorporation's more likely to protect you.
Right.
We'll protect the secretary to some extent. One of the issues in unincorporated associations is who are the members?
Yes.
And are they the members today, or are they members, or they are the members 3 months ago when the offending letter was written?
Right.
So if we make it really clear, then the general proposition is that you would sue the organisation. But depending upon what the statement was, there may be some liability on the writer of the letter. But I would have thought from an environmental point of view, you tend not to be. You're basically saying that the minister or the department has got it wrong, not that you're an idiot. Isn't that a general proposition, John Douglas? I mean, normally your comments are that, you've got it wrong, you've taken wrong things into account, you've misunderstood the position, but you tend not to get personal.
That's right, yes.
All right, then I think the risk is low, but I haven't seen your secretary's writing. But I would be going for incorporation because then we know very well who the body is, and we can set up rules as to who's allowed to speak on its behalf.
So it's worth.
I would do it anyway.
It's worth the $60 a year out of our members' fees to do it, to offer some extra protection. In other words,
not just that either. It also is better for internal democracy, decision making, long-term planning. There's a whole lot of reasons to incorporate, not just protection from people suing you.
Not like a takeover by the current committee, for example.
All right, Douglas?
Indeed. Look, thanks very much for that, gents.
Okay, and there's a do-it-yourself kit available. There's lots of ways of doing it.
And there's standard rules, John. You
Standard
can actually
rules.
download the rules and away you go.
Yeah, fill in forms. It's not that complicated anymore, okay?
Thanks very much.
In Bentley, hello, Rhonda.
Hello, John. Hello, David.
Hey, Rhonda. Far away.
Right, I'm ringing about an incident that happened yesterday at my local shops down in Bentley, and I need to have some idea of what consumers' rights are regarding in shops and having somebody from the shop staff basically follow you around the shop and continue to harass and confront you and subtly accuse you of trying to shoplift. It developed into a rip-roaring argument, which was very unpleasant.
Yes.
And I stood my ground, said no. She kept wanting me to put things on the counter instead of carry them round on my bag, which I did because I needed a free hand, of course, to, still continue shopping.
Yes.
And I did take my time. I had plenty of time. But she kept harassing me very loudly until in the end I had to stand up for myself. Now, my understanding may be wrong. That's what I want to know. I thought that you were not shoplifting, definition, until you've actually left the store without paying for the goods.
Well, that's the way it works in a self-service store, and which may be a supermarket, it could be a shoe shop, it could be anything.
One of those $2 variety
shops, right? Then where you get to is that we describe the display of the goods as being an invitation to treat.
Yes.
It's a beautiful legal phrase,
yes.
But by displaying them, you're indicating that the shop owner is indicating that he, she or it is willing to consider an offer you might like to make to buy them, and hopefully at the price indicated below.
Yes.
So you take them to the front counter.
Yes.
Now,
now I hadn't finished shopping.
No, I accept that, right? So you take them to the front counter, and at that point you make the offer to buy, which they accept by scanning and charging you the money.
Yes.
Now, but if you put things in your pocket and walk around
if you
the
put
shop,
things in your pocket, what we're now talking about is dealing inappropriately with items. So if you put them in your handbag instead of in a wire bag that they provide for that purpose, then my argument is that you're dealing inappropriately with those items. Now, every case will be slightly different, but that to me would be the general proposition. That's not where you put them.
That would probably affect 90% of the population.
Well, yeah, I understand, but the general proposition is that I would have thought if you put it in your pocket or you put it in your handbag and closed it over, then...
No.
I'm not asking you. You're asking for general principles here.
Yes. Okay.
Right? Now let's take it the next step. I'm a shop owner. You come into my shop. I'm not happy with the way you're behaving. I can tell you, and you can modify your behaviour, or I can ask you to leave, both of which are open to me.
Okay.
So you are the presumption in the retail outlet is that the door is open, you are an invitee. Mm-hmm. But my invitation can be withdrawn at any time. So I don't like what you do, Kate. I don't like what you're doing in my shop, so I'm asking you to leave. Right?
I hope there are a lot of people listening to that because we would
we do too. No, not shaking. No, the answer would be, look, it's only a very small proportion of the population that this affects. And, if they have a shopping basket at the front, I actually look at the the rules we've got now in relation to the supermarkets that don't provide plastic bags, I tend to walk in with one of the bags. I have two in the car, one so that I've got a Coles one that I take a Woolies and a Woolies one that I take to Coles, just because I'm a rat bag. And that's what I tend to use as in lieu of a shopping bag, and that creates a problem.
I hope that helps you understand it all, Rhonda in Geelong. Hello, Kate.
Oh, good morning, gentlemen. Thanks for taking my call. I've got an 18-year-old son who was wanting to buy a car. He had a number of pre-purchase inspections showing different warnings, so he didn't buy them. They showed amber warnings, red warnings, so he didn't go ahead and buy them. He finally had one that showed all green warnings.
So I don't understand.
These are for different cars, different inspections on different cars.
Yeah, no, I understand that, but who provides the colour warning? So RACV or someone else who does a pre-purchase inspection. Yep, okay, yes. But I mean, my view in relation to pre-purchase inspections is unless you put it on a hoist and have a really good look, it's not perhaps as detailed as, it's not, well, I don't know how well they do it or anybody does it.
Anyway, what's the dispute about? What's happened, Kate?
Going to be able to show everything that,
No, never. I mean, I had a client who bought a house in Castlemaine and got a termite inspection, which didn't show any termites, but they made themselves well known about a week later.
Okay. So, well, look, it's tricky. I guess there's a few. Well, the big issue is that 3 days later, on the road, on the freeway, the temperature gauge suddenly went up and the car stopped.
Yes. Yep.
And the problem is that it is a head gasket that we've now found out has had evidence of sealant in it.
Yep.
So it's clearly been.
How much did the car cost, Kate?
$13,000.
And how much is the cost of repair?
Well, that's what we're discussing at the moment because we're being told that our son may have contributed to...
Yeah, he drove it. That definitely contributed to the problem.
Exactly. And it was, 3 days after having had
I would actually ask a different question, not related to the time.
Yes.
Would the problem with the head gasket have been apparent at a pre-purchase inspection? If the answer is it would have been, then it's a matter that you take up with the person who provided the pre-purchase inspection.
And the vendor.
And well, if you're buying from a dealer, you've got consumer law problems.
Was it private purchase, Kate, or from a dealer? Hey?
It was a private purchase. So we can go back to the vendor and have that discussions with them. Or we can go down...
Well, yes, but you don't have the Australian consumer law rights that you would have if you bought from a dealer. So I think you need to talk to a garage. You come along and say, here's my pre-purchase inspection. Should this have been seen?
Now, there are some pre-purchase inspections I've seen, Kate, which are to do with safety and roadworthiness. And there are some that include safety, roadworthiness and mechanical condition.
I think this was a mechanical condition. It was a comprehensive one, so I think it was a more detailed one. But whether it's going to show something like that is obviously quite well hidden.
Okay, now the problem also next is that sometimes fixing a head gasket is expensive. Sometimes fixing a head gasket is not very expensive. You might find it costs you more, David, to have the dispute than the cost of the repairs.
Yes. All right, so that will depend a lot on the head and how old the car is, all sorts of issues.
Whether the head is warped and needs to be shaved and so on, what sort of make it is and how complex the parts are and expensive they are. So there's a bit more to this than at first blush meets the eye, Kate.
Okay. All right, well, we'll go down the negotiation route and see how we go.
Have you got a mechanic you trust?
Well, that's the trick because it's currently in the mechanic who did the original inspection.
Okay.
He's insisted that it go back to him rather than be...
you need an independent assessment.
Yeah, you need someone else to have a look at it. You really do.
Okay.
Thank you, Kate.
All right, thanks for your time.
I feel like I'm giving car advice.
You are, John. You're doing a great job. We could start another half hour, would be right.
Oh, look, maybe we should do. In fact, you'd be kind of handy too. You're not a stranger to some of these issues.
No, I have. So the difference between you and me is I own them and pay someone to fix them.
Yeah.
And you fix them.
I fix them badly and then have to pay someone even more to do the job properly.
Oh, okay, so I am being clever. Okay.
Nick in Northcote, morning. You're through to David.
Oh, good morning. Good morning, gentlemen. My question is about adverse possession. My brother recently bought a house in a sort of semi-country town, and after having a look, close to the fence there were a few pegs and some stone fruit trees built. And anyhow, he decided to call a surveyor and see what's happening. And apparently the neighbors encroached into the property on a semicircle in the middle of it by about 2 meters.
Yes.
So he informed the neighbor, and he was threatened with violence. It just all went stupidly.
Yep.
So
Didn't go well.
Didn't go well at all. So what does he do? He bought it legally through the estate agent, the proper owner. What is his next move?
Well, if you got threatened with violence, I'm mildly apprehensive
that's
here.
been settled.
Nick.
That's not,
The question is really, how long has the neighbour occupied part of the property your brother has bought?
Yeah.
And is the occupation sufficient? So planting a tree probably isn't, building a fence is, putting some stones down may or may not be.
So you have to, for adverse possession, you have to, what is it? You have to
Exclude other
the
people
world
for more than 15 years.
entirely,
Yes.
completely and utterly.
So they'll allow an adverse possession claim where the boundaries are road, but they won't allow an adverse possession in circumstances where there's no physical marking of the boundary.
well, there were some pegs there, and that's about all.
I would take it a bit further because the general proposition is that because it's the pegs that interest me. So I would be ringing the surveyors in the local area to see if they've done a survey on the property, and you might get someone to check at the Land Titles Office, because if there is a re-establishment survey done, the details of the survey are normally given to Land Use Victoria for the purpose of improving the quality of the records there.
Alrighty.
All right.
Hope that helps you.
And the last thing I would do would be find out how long your neighbour has owned the property next door.
In case they haven't even been there that long.
Yes.
Yep, good point. RACV inspection should have shown a head gasket failure, says a mechanic. Sold a car for $12,000 to a friend. It was perfect. 2 days later, a hose burst. Who could have picked that? Head gasket went because there was no water. Stuff happens. I paid for the repairs $1,800. Fair bit of correspondence.
There you go. You should have them on the project. Thank you, John.
Often thought there's room for a motoring advice program. But
well, I got really upset when you gave up computer advice.
Yeah, I know, but it became a bit monotonous because it was always the same thing. If you turned it off, if you turned it on, if you updated the software, it became like it was the same advice over and over again.
I have the IT crowd we've got. That upsets me greatly because I said, you haven't solved the problem. You've just hidden it for a bit longer. Thank you, John.
And the other thing about the car advice is it's very hard to do without constantly advertising different brands. So that came to grief there too.
Thank you, John.
David Whiting, our talkback lawyer, helping you with free legal advice on a Tuesday, 10 o'clock. If you didn't get through today, have a crack at it next week.